Half a day, the Committee on Culture and Justice is now called to order. Today's Friday, September 28, 2018. It's 11:05, and we will now begin this meeting. Invitations for this status briefing meeting for the committee were disseminated via email to all senators and the main media broadcasting outlets on September 25 and again on September 27, and published in the Guam Pacific Daily News on September 27. The agenda items that will be discussed today are the following: an update on the status of the Davis versus Guam lawsuit, an update on the status of the gambling litigation case, that is the Attorney General of Guam versus Governor of Guam and John Camacho, Director of Department of Revenue and Taxation, an update on the status of government land registration cases. Before I begin, I'd like to acknowledge the presence of my colleagues and thank them for being here this morning, beginning with Senator Tom Ada, Senator Jim Espaldon, and Senator Joe San Augustine. The purpose of this status briefing is to get an update from the Attorney General on a couple of court cases her office has been working very hard on. I'd like to ask the Attorney General and her team to come to the table and introduce themselves for the record, and thank you all very much for being here this morning. Okay. If you could just, will it just be you this morning, Madam Attorney General?
Right now, I'll deal with two issues, the Davis case and the land registration case. And Mr. Orcutt will be here to talk about the status of the gambling case, which is might still be at the Supreme Court, but he'll be here shortly. All right. He's working on a very important brief for the Chamorro Land Trust case.
Okay, thank you. Okay. So the first item then on our agenda is the status of the Davis versus Guam lawsuit. In 2011, the Guam Election Commission and Decolonization Commission were sued and stopped from conducting a Native Inhabitants Registry and preparing to conduct a plebiscite, which would have been a non-binding vote on which political status the people of Guam preferred. The lawsuit was brought against Guam in the U.S. District Court and has proceeded to the Ninth Circuit Court of Appeals for hearing on October 10, 2018 in Hawaii. The legislature passed Resolution 51-34 last year, supporting that the government of Guam move forward to appeal the ruling of the District Court of Guam to assist in defending the rights of the native inhabitants of Guam. According to the United Nations, Guam is one of only 11 remaining non-self-governing territories that have yet to exercise self-determination. In recent UN Fourth Committee on Decolonization votes on resolutions calling for a self-determination vote for the people of Guam, the United States has objected. So now I would ask the Attorney General, thank you again for being here, and I'm just going to state for the record some of the general questions that I've talked to you before the hearing about what I was hoping that the public would just hear and that our senators would all be apprised of regarding this case, what has happened in it, and what is the purpose of the hearing on October 10 in Hawaii. If you could tell us who could attend that hearing and will it be live streamed? Is there any way that the public could listen to it? Would it be recorded for us to listen later perhaps? And if you could share, and I know that with the hearings pending so that you are very conscious of what you say today, but if you could share some of your arguments on behalf of the government of Guam and what the expected timing of the decision would be or what we should expect going forward.
Okay. Thank you very much, Senator, and thank you for calling me before scheduling this. And Senators, I'd like to preface what I say today in the same manner that I prefaced with the Vice Speaker, is that although I'm here today, I am very careful and cautious about a public discourse about the arguments and the case that is soon to be brought before the Ninth Circuit Court of Appeals in about a week and a half, that I not engage in a very detailed presentation of the legal arguments. I'm never in favor of arguing the case until it's ready to be argued. So if I do not answer any of your concerns or your questions, please recognize that we are on the eve of the oral arguments in the Ninth Circuit. And to the extent that I can at least advise the legislature, which has been very supportive and interested in this issue, as well as the general public, about the Davis case, which is what it's known as, or the plebiscite case, I told the senator I'd be glad to be here and do my best. I'd like to provide the senators, if one of your staff could come before me, just a brief one-page outline of the history of this case. I think a lot of people have heard about it, but unless you're in the legal community or the government or the political community, you just hear about the plebiscite case but don't know why it is and where we're at. In November 22nd of 2011, Mr. Arnold Davis, a resident of Guam, filed a lawsuit in the Guam District Court seeking a review of the denial of his ability to qualify to vote in the decolonization law plebiscite, a law that was passed in '96. The reason why Mr. Davis was denied the right to vote in that particular decolonization vote is because he did not meet the qualifying definition of persons who can vote. Persons who are allowed to vote in the decolonization plebiscite vote must meet the qualification of native inhabitant. Native inhabitant is taken from the terminology in the Organic Act of Guam. It's a terminology created by Congress, which states that a person is a native inhabitant if they were on Guam at the time of the 1950 Organic Act and became citizens, United States citizens, by reason of the Organic Act. And I'm not sure if it's and or, but I believe it's and their descendants. Sometimes I've been reading here and there, very flippant and or, I think it's an and. So Mr. Davis, although a resident of Guam, did not qualify as a native inhabitant. Mr. Davis's 2011 lawsuit was dismissed by the Guam District Court Judge, Judge Gatewood, Tadinko Gatewood, on January 9th, 2013, on the basis that his complaint was not ripe and that he did not have standing. Basically, senators, Judge Gatewood indicated that no vote is pending. And if no vote is pending, then this lawsuit is not ripe and it shouldn't go forward. Mr. Davis then appealed to the Ninth Circuit Court of Appeals in January of 2013. I became Attorney General when the oral, actually I was in, we were campaigning, Mr. Rapadas and I were campaigning during the period that the oral arguments on the appeal were heard here on Guam. I don't remember exactly in 2014 when the oral arguments were had, but it was the winter of 2014. By May of 2015, the Ninth Circuit issued its decision reversing Judge Gatewood's decision and remanding the case back to Guam for further hearing. The Ninth Circuit disagreed with Judge Gatewood that that Mr. Davis didn't have standing. They ruled that he did because he was denied his right to apply for a vote, that even though the vote was not scheduled, the mere fact of his denial gave him sufficient standing. The court also stated more clearly that being that he was excluded from the registration process, Mr. Davis's claim is an unlawful, Davis complained he is unlawfully denied the right concurrent with others. On remand, the District Court of Guam, and I was Attorney General at the time that it was on remand, we had a full hearing on remand. And on March 8th, 2017, that's last year, the District Court of Guam ruled in favor this time, of Mr. Davis's claim on his summary judgment motion. The District Court of Guam ruled as follows. There are a lot of rulings, but I'm only going to, for purposes of this educational effort, the District Court reviewed the law's historical context and concluded that the Guam Legislature's enactment of Native inhabitants distinction was racially discriminatory and had a discriminatory purpose. So the definition of Native inhabitant, the District Court ruled was discriminatory, and further, the District Court held, Judge Gatewood held, that Guam's law violated both the Equal Protection Clause and of the 14th Amendment and the 15th Amendment Voting Clause of the United States Constitution. I know we have two lawyers here, so basically, and no disrespect to the other senators, we have a 14th Amendment and a 15th Amendment ruling by Judge Gatewood. On April 7th of last year, I made the decision to file an appeal challenging the decision of Judge Gatewood. It is my position that Guam's statute does not violate either the 14th or 15th Amendment, that the cases that were cited in the court decision do not apply to a purely political status plebiscite vote that does not change anything. Senators, I know it's an uphill battle on this case because the courts of our nation and the Supreme Court of the United States are very guardful of equal protection violations under the 14th Amendment. And of course, something that we are all very familiar with is the right to vote. And that also is a constitutional right very much protected. However, I want to let you know that I believe the arguments that have been filed are very good arguments. The fact that the Dean of Bolt Law School has looked at our arguments and supports the concept of our arguments is very reassuring because of the very difficult uphill battle we have on these cases. The court will hear this argument on October 10th at 9 a.m. in Honolulu, Hawaii. It will be before a 3-judge panel. It will be held not at the Federal District Court, but at William Richardson's Law School at University of Hawaii. I am informed that you wanted to have some information of whether it was going to be televised. I am not aware that it will be televised so that we could just turn our television on. Hawaii is only 4 hours ahead, as we know. But I think there is a mechanism, senators, that if you would like us to find out how you might be able to listen to the arguments as opposed to, I'm not sure if it's going to be televised. We haven't gotten information from the Ninth Circuit on that. I'll pass on any information to any of you that are interested in listening in. That will then be 5 o'clock in the morning, Guam time, okay? I will be there. Deputy Attorney General Ken Orcutt and Assistant Attorney General Julian Uggan will be our primary counsel to argue the case on behalf of the government of Guam. I understand that Richardson School of Law auditorium, this particular auditorium that the Ninth Circuit is using is a very small auditorium. I informed the senator that I think it only holds about 50 maximum, which is very, very small. I have heard from individuals in the state of Hawaii who are active in the Hawaiian and Ohana organizations there that people in Hawaii are looking to attend this case. They are very concerned, and they will follow any case that also might have an impact on the rights of the native inhabitants or the Hawaiians or other native groups in the Pacific. I'm not quite sure how you get in. I do know that certainly councils will be at table. If you would like me to try and get some information from Richardson Law School, how seating will be arranged, I'll try to do that if any of you are interested in that. Senators, I think the other question, Madam Vice Speaker, you asked is, so after the oral arguments are done, what happens after that? I am somewhat aware that federal judges, just like Superior Court judges, have timelines to get their decisions out. I don't know if that's a 3 or 6 month timeline for the federal judges. If it's an appellate court, maybe it might be longer. I'm hoping that the decision from this Davis appeal will come out within 6 to 9 months. I will no longer be Attorney General at that time. If there are several options available to either side who loses. I'm hoping that we win. If we win and the other side loses, these options are also available to the other side. But the unsuccessful party, after the Ninth Circuit has rendered its decision, has the option of requesting a hearing, a rehearing en banc, which means a hearing before 9 judges of the Ninth Circuit Court of Appeals en banc. That is completely in the discretion of the Ninth Circuit to have a hearing en banc. If the Ninth Circuit believes that this issue is important enough to have 9 other judges review it, then we'll have an en banc. The other option is it's possible that the Ninth Circuit will remand the case back to Guam again with instructions to the District Court of Guam as to what to do for further hearings. So that's also another option. And I think the third option that most of you are familiar with is the unsuccessful party has the option of filing a review before the Supreme Court of the United States, a writ of certiorari. Again, it is discretional for the Supreme Court of the United States to take any type of case, and that is the third option. We won't know what option either losing party will take, whether if the government of Guam is not successful. It really all depends on a review of the decision, the way it's written by the Ninth Circuit, whether we ask, a party ask for Ninth Circuit en banc or to the Supreme Court of the United States. I will not be Attorney General at that time, but I will tell you that the staff of the Office of the Attorney General and certainly Special Assistant Attorney General Julian Uggan will still be around, and I will fully brief the incoming Attorney General on this matter, and I have every confidence that the next Attorney General of Guam will make the right and appropriate decision at the time. Madam Chairwoman, is there any other question I did not answer with regard to the Davis matter?
No, but I do want to just say thank you to you for personally, spearheading this on behalf of all and working with all these other lawyers that have now. And I want to thank Ken Orcutt, Deputy Attorney General Ken Orcutt, Assistant Attorney General Julian Uggan. I've read the briefs and I think they're excellent, of course. And I was ecstatic to hear through a press release about that constitutional law expert Erwin Chemerinsky of Bolt Law, as you say, and for those who aren't familiar, that's UC Berkeley's School of Law, has agreed to assist in this case, and he's considered one of the foremost constitutional law scholars in the United States, and also the dean of the law school at this point.
You ask any law student, they'll say Erwin Chemerinsky. Oh my goodness. Wow.
Yes, because I was going to say he wrote the textbooks we used for constitutional law when we were in school, and so it's very impressive and very exciting for us on Guam, I think. I'm excited. I'm excited for the hearing, and I'm excited by the arguments that we are making, and I'm proud of the team that you've put together and the efforts that you've made.
It is exciting, Senator. Absolutely exciting. It's a case that is not difficult on its facts, and I'm hoping that if this case, for whatever reason, makes it to the Supreme Court, that the Supreme Court takes this case, because it is not heavily fact-driven. It is really legally driven on the Constitution of the United States, and also the issues dealing with territorial status. If I could predict, I think the Supreme Court would, but we'll have to see.
All right. I'd like to ask my colleagues if they have any questions that they'd like clarification from the Attorney General. Again, thank you very much.
Thank you very much. The next topic that I would like to give a review on is the land registration matters. Right. And Madam Chairwoman, thank you so much for bringing this up about a year ago. And I was not aware that the land registration cases, there were about, I didn't even know how many there were. I found out there were about 32, were actually in limbo. And I like land registration cases. I like land cases just generally. So I immediately told my staff, find those cases. And we ended up with about 32 cases. There were a little bit more, maybe about 40-some, but the trial court judges in the Superior Court of Guam had called status conferences, and the Attorney General's office did not move on them, so dismiss, dismiss, dismiss. We had about 14 dismissals of land registration cases that we had not moved forward on. So we have had to refile those cases. They are now active with the litigation division. Assistant Attorney General Nick Toff is assigned to those cases. He is counsel for Department of Land Management, but he is also doing the land registration cases. We are refiling the maps. We are refiling the complaints to register the property, and we are redoing the notices required for land registration. And Mr. Toff periodically reviews those cases with me.
I'm sorry, did you say you're redoing the maps?
Certification of the maps.
Oh, okay. All right.
So sorry. We have to recertify the maps and then refile the complaints, and then do service all over again, service of the notice of our complaints to the surrounding landowners. And Mr. Toff is actively on those cases. I've not heard, actually, I do believe he said we've got maybe 1 or 2 judgments entered. We've asked for the Superior Court judges. They're assigned across all the judges. And we've asked for status hearings on the cases that we could go forward, and we've had a few judgments entered. I can just tell you, Senator, thank you for bringing it to my attention, because I was not pleased that those cases were either somewhat lost or in limbo, and I'm sure the Superior Court judges were not happy about that as well. I do ask the legislature to give the Department of Land Management and the various commissions, we've also encouraged them, the Chamorro Land Trust Commission primarily, when they have income coming in, to use that income to register property. I think generally I've been asked the question, can you lease unregistered property? How about I say, Senator, it's better, much better, to lease registered property so that there's no question about title. So I do encourage this administration, Department of Land Management. Mr. Borja is committed to registering as many properties as possible, but it does take money. It does take money to do so. And again, I will encourage the next Attorney General, don't lose these cases. Don't lose track of it. It is very, very important that the government of Guam continue to register its property.
Thank you. I just wanted to also say very generally, just for those who are listening, that registering the land is really the government's way of declaring these are its boundaries on government-owned land, and so that those who are especially adjacent landowners, they settle all disputes with boundaries, and going forward, I mean, it protects the government and the government's interests. And I wanted to commend you because during this period, since we had our last status update on land registrations, I believe there was I'm going to use your words here. You said there was one more lingering case, and you said it was the conclusion of the, quote, final vestiges of what has historically been known as land scam. And I think that's why I was curious about the land registration, is because it's unregistered government land that allows funny play to occur on the boundaries of these government. And as we know, we've got huge tracts of government land that have yet to be registered and just recorded, and so that it's useful for everyone else also.
I'm very proud of Assistant Attorney General Nick Toff and Assistant Attorney General James Collins, who worked together, James in the prosecutor's office and Nick in the litigation and solicitors division. They worked together, and usually the criminal division and the civil division don't necessarily talk to each other, but when it came to my attention, I said, start working together. I was actually surprised that there was still a lingering land scam case. And you're right, Senator, we have to be the guardians of government property, and the only way to best be the guardian is to register our property. Because if we don't register it, then someone else is going to try to register over our property. And if we're not awake or we're asleep at the wheel, and that judge hears no objections, and boom, that gavel goes down, and there's a judgment for Mr. X or Madam Y. And then the government goes, oh my goodness, that's our property, and we need to do some government purpose on that, an easement or something. We have to go into court. And if it's too late because a judgment is there, we may not get that property back. So the way to prevent these types of over-surveying, overtaking, or land scams is to get our property registered first. We do actually, I believe, we still have a few cases where we have to prove that we own the land, but nothing to the extent of the land scam.
All right, thank you. So at the last status briefing, there were 83 lots, 7,920 acres that had been surveyed. There were 37 lots that needed to be surveyed. Do you know, I guess we can follow up with land management, but I didn't
Exactly. I don't have the answers for you right now on how many cases have since been filed since we last talked. But because I have a full-time attorney for the Department of Land Management who knows how to file these cases, and if land management has the money for the survey, has the money for service of process to the adjoining landowners, it's not a difficult process to register a piece of property. You can actually register if you have everything together and the judge has time in 6 months. You could literally register in 6 months. I think what happens, though, the registration, if there's no objection, takes a little bit longer, only because of the judicial calendar. And the trial judges will place criminal cases before any civil case, and I'll tell you it's criminal, civil, and then LR is kind of the third in line. But we do try to push the judges for status hearings. And if there are no objections, the judges are more than glad to squeeze our cases in so that we can get judgments.
All right. Well, I want to thank your office again, and Attorney Nick Toft, and you and all the management for helping Department of Land Management. I know that they were very diligent about, confirming which ones had been surveyed, and they knew they were ready. They wanted these to be registered. So I commend them also for their work in this regard, and your office for the support they can't do it without you. So I very much
Senator,
appreciate that.
Again,
yes.
The next AG, that will be among the list of things. We cannot let these LR cases go unattended again, ever again.
Thank you. Do any of my colleagues have a question? Senator Espadon?
Thank you, Madam Chair. Madam AG, thank you for the presentation both on the Davis case as well as the land cases. while I was listening to all this, something came to mind that I hope you don't mind that I ask, and of course, however you answer, I'll take it. I believe that in regard to the Chamorro Land Trust, I believe that there was a decision or two rendered by the courts that the Chamorro Land Trust Act was unconstitutional. And I guess the question I have for you is, will the ultimate determination of the constitutionality, the ultimate determination in the Davis case, since we are talking about the 14th and equal protection and whatnot, will that have an effect on the issue of the constitutionality of the Chamorro Land Trust?
Why did I think that was going to be asked? Well, Senator, obviously the commonality between the Chamorro Land Trust statute and the decolonization vote statute is the definition of native inhabitant, and it's the same. Judge Gatewood, in her decision in the Davis case, did incorporate and throw in the Chamorro Land Trust Act in her ultimate decision to say that the Decolonization Act was violative of 14th and 15th, and she actually kind of threw the same stuff on the Chamorro Land Trust, although the Davis case is not about the Chamorro Land Trust. But it appears that you've read Judge Gatewood's decision. We don't have a decision in the Chamorro Land Trust lawsuit being filed by the Justice Department against Guam and the Chamorro Land Trust. We are at the early stages. We have a motion, our motion for a judgment on the pleadings. The U.S. Justice Department has filed their, is it a summary, motion to dismiss? I'm sorry, judgment on the pleadings themselves. We would file the motion to dismiss. So there's cross motions for judgment on the pleadings. Let me ask Ken to at least give you an idea procedurally when the pleadings close on those motions.
I'm sorry. I should say good morning, Senators and Vice Speaker. I'm Ken Orcutt. I'm the Deputy of the Litigation Division. The deadline for filing our opposition to the United States motion for a judgment on the pleadings is Tuesday, so we're in the process of finalizing the brief, really as we speak here today. The judge is coming out, I believe it's November 29th is going to be the date for oral argument in the Guam District Court on those motions. We anticipate that the court will probably take the motions under advisement and will issue a decision at some later date. At this point, there's no scheduling order in the case. There's no trial date. The prior scheduling order has been vacated so that the judge has an opportunity to consider these motions. The judge hearing the case is a federal judge out of Honolulu, so she'll be flying out to hear oral argument. So I don't believe we're anywhere close to resolving the Chamorro Land Trust litigation at this point. I think it's going to be a process that's going to take some time to play out.
So in answer to your question, it all depends who wants to use a particular case as a sword or a shield.
Right. Okay. I appreciate that. Thank you. Had to ask.
Okay.
Thank you, Madam Chair.
All right, thank you. I was going to recognize the presence of, we had an observer earlier, of CNMI Speaker Ralph Demapan and Senator Will Castro. So finally, the final item on our agenda, welcome Mr. Orcutt.
Oh.
Thank you for being here, it's just a status update on this, the litigation regarding the gambling machines. If you could, I think in the 2017 informational briefing, you informed us that in that case was under interlocutory appeal and awaiting a decision from the Supreme Court. And your office was arguing that the regulations which authorize electronic gaming devices violate Guam's prohibition of gambling devices and are contrary to the law. And you had asked the court to rule that the regulations are void and that any licenses issued pursuant to the regulations are also void and must be revoked. And so the Attorney General told us earlier this was a case that preceded her even becoming the Attorney General. But if you could give us an update.
Okay.
Thank you.
Thank you. The oral argument on the interlocutory appeal was held, I believe, February 28th of this year. And the issue on appeal is a collateral issue. It involves basically who has to pay for the governor's legal counsel. The lower court's order, Superior Court's order, was that our office would have to pay for that, which implicated, separation of powers issues. And so I say oral argument was held in February. We believe oral argument went very well. We're anticipating a favorable decision, but of course, one never knows. But at this point, there's been no decision rendered by the Guam Supreme Court. Once that happens, then the case would be remanded back to the Guam Superior Court, and the pending motion for summary judgment to basically have a ruling by the court in favor of the government of Guam, in favor of the Attorney General, saying that these gambling regulations are invalid, would then proceed. Again, it's going to be, my best guess, most optimistic guess is that it's going to be, again, months before we reach a resolution on that underlying motion for summary judgment.
Are you able to tell us how many licenses you are talking about in that case?
It's been several years since I looked at it. We did request information from Department of Revenue and Tax on that, and we did receive a very long list. I wouldn't feel comfortable giving you an estimate on what that is, but it was a significant number of establishments that would be involved in this.
All right. Well, thank you. So you're waiting for a decision on the interlocutory appeal, and then you will have a hearing on the summary judgment motions.
That's what I'm anticipating.
Okay. All right. Any of my colleagues have any questions? No. Senator? All right. Well, I want to thank you again. Unless any of you have anything else you'd like to add, I want to thank you again for your cooperation and being here today, for your briefing us. I think it's very important that we are aware of what's going on in these cases where the government of Guam is the party, and of course the people. I'm hoping that they'll be able to hear what you've said and have optimism in our case, and just be informed. That's really the goal. So I thank you again. Thank you very much. This meeting is ended at 11:43. Sizus Masi.